If you teach firearms training, or you're planning to take a concealed carry class this year, there's a legal trend building quietly across the firearms training industry that almost nobody is talking about directly, and it could reshape who actually gets held responsible when a student who completed training later misuses a firearm. Firearms instructors, some with decades of experience and thousands of students behind them, are increasingly finding their training records, their certification standards, and their own professional judgment placed directly under a courtroom microscope after a former student is involved in a shooting, whether that shooting was criminal, accidental, or a case of someone freezing at the exact moment they needed to act. This isn't happening through one single dramatic court ruling that made national headlines. It's happening gradually, case by case, in courtrooms most people never hear about, which is exactly why it deserves a closer look now rather than after it's already fully reshaped how training gets delivered nationwide. I'm going to walk you through exactly what this legal trend actually is, the real legal doctrine driving it, why it's accelerating right now, and what it means for both instructors and the students who sit in their classes. Before we get into it, if you want to understand legal trends before they fully arrive at your own doorstep instead of after, subscribe and turn on notifications right now. This is exactly the kind of slow-building legal shift that doesn't make a single dramatic headline, but ends up reshaping an entire industry over several years. And by the time it's obvious enough to make headlines, the instructors and students caught in the middle of it have usually already been dealing with the consequences for a while. Let's get into exactly what's happening. Here is the legal concept at the center of this entire trend, and it has a name, vicarious liability, along with a related concept called negligent training. The basic idea is straightforward. If an instructor certifies someone as competent to carry and use a firearm, and that person later causes harm in a way that a reasonably thorough training program should have prevented, or at least flagged as a risk, plaintiffs' attorneys are increasingly willing to argue the instructor, and sometimes the training organization or range that employed them bears some legal responsibility for that harm, not just the person who actually pulled the trigger. This isn't a brand new legal theory invented out of nowhere. It draws on decades of established law governing how courts evaluate training adequacy in other high-stakes contexts, most notably law enforcement. The first segment of this story is where this legal framework actually comes from, because understanding the origin matters for understanding how it's now being applied to private firearms instruction. In 1989, the Supreme Court decided a case called City of Canton versus Harris, establishing that a municipality can be held liable for a constitutional violation caused by inadequately trained police officers, specifically when the failure to train reflects deliberate indifference to the rights of people the officers interact with. That case built an entire body of law around what courts call failure to train claims in policing, focused specifically on whether a training program was adequate in relation to the actual tasks officers needed to perform, covering both proficiency, meaning the physical skill of safely and accurately handling a firearm, and judgment, meaning the ability to correctly decide when using that firearm is actually appropriate. For decades, this body of law stayed largely confined to lawsuits against police departments and municipalities. What's changed recently is that plaintiffs' attorneys, personal injury firms, and civil litigants have increasingly started applying strikingly similar reasoning to private firearms instructors and training organizations, arguing that if courts hold police departments accountable for training adequacy, the same basic logic should extend to any instructor who certifies civilians as competent and safe to carry. The second segment is what this actually looks like in a real courtroom, because the theory only matters if plaintiffs can actually make it work in practice. When a former student is involved in a shooting incident, whether that's a self-defense situation gone wrong, a negligent discharge causing injury, or a case where someone froze during an actual threat despite having completed training specifically meant to prepare them for that moment, attorneys representing an injured party or a grieving family have started routinely subpoenaing the instructor's complete training records for that specific student. That means the instructor's lesson plans, their documented qualification standards, whatever notes exist about the student's actual performance during training, any concerns that were or weren't documented at the time, and the instructor's own certifications and credentials all become potential evidence, reviewed and cross-examined in front of a jury. Attorneys and firearms law specialists tracking this trend describe a courtroom question that increasingly gets asked directly: whose signature said this person was ready to carry a firearm, And does that signature's training history hold up under scrutiny? The third segment is why this trend is picking up momentum specifically right now because it's not happening in a vacuum. Part of it reflects a broader nationwide expansion in who can legally carry firearms, with more states adopting permitless carry and more people overall completing voluntary training, even where it's no longer legally required, meaning simply more total students are moving through more total training programs than in previous years, mechanically increasing the pool of people whose training history could eventually become relevant in litigation. Part of it reflects a genuine, separate legal trend of expanded liability theories being tested against firearms manufacturers and sellers more broadly, including state laws specifically written to create new legal pathways for holding parts of the firearms industry accountable for downstream harm, a legal environment that has made plaintiffs' attorneys generally more willing to test creative liability theories throughout the entire firearms ecosystem, not just against manufacturers, but against anyone in the chain who touched a person's path toward carrying a weapon, including their instructor. The fourth segment is the argument driving this trend from the plaintiff's side, and it deserves to be presented fairly because it reflects genuine concerns about training quality that aren't unreasonable on their face. Advocates for stronger instructor accountability argue that firearms training, unlike many other certification processes, carries genuinely life or death stakes, and that an instructor who signs off on a student without adequately evaluating whether that person demonstrates sound judgment, not just marksmanship, is making a decision with real consequences that extend well beyond the classroom. They point out that minimum state-mandated training standards for concealed carry certification are often extremely brief, sometimes just a few hours covering basic safety and legal information, arguing that an instructor who simply meets that legal minimum without exercising genuine professional judgment about whether an individual student is actually ready isn't providing meaningful preparation, and that some legal accountability for that gap is a reasonable way to push the entire training industry toward higher, more consistent standards. The fifth segment is the argument from instructors and training organizations facing this expanding legal exposure, and it deserves equal weight. Their position centers on the practical impossibility of what's effectively being asked of them. An instructor typically spends a handful of hours with a student during a single class, evaluating basic safety habits and fundamental marksmanship, not conducting the kind of extended psychological evaluation that might actually predict how someone will behave months or years later during a genuine, high-stress emergency they've never previously faced. Instructors argue that holding them liable for a former student's later conduct, sometimes occurring long after training concluded, and under circumstances the instructor had no ability to observe or influence, stretches the concept of causation well beyond what's fair or even logically coherent, and that the practical effect of this expanding liability theory will simply be fewer available instructors, higher training costs, and more instructors declining to certify borderline students out of pure liability fear rather than genuine safety judgment, potentially making the overall training landscape worse rather than better. The sixth segment is what this trend means for the broader firearms training industry structurally, beyond any single instructor's individual liability exposure. Training organizations and individual instructors are increasingly investing in more thorough documentation practices, specifically anticipating future legal scrutiny, detailed lesson plans, recorded qualification standards, explicit written policies about what disqualifies a student from certification, and more comprehensive liability insurance coverage specifically tailored to this kind of exposure. Some instructors report adjusting their own teaching practices, becoming notably more willing to fail or decline to certify students who exhibit concerning judgment or safety habits during training, even when that student technically meets the bare state-mandated minimum standards, precisely because the legal environment has shifted the calculus toward documented caution rather than simply checking a required box. Let's step back and name the single thread running through this entire trend. This isn't really a story about one specific lawsuit or one specific instructor. It's a story about an established body of legal doctrine, built originally around police training accountability, gradually migrating into an entirely different context: private civilian firearms instruction, as broader shifts in gun ownership rates, legal theories around firearms industry accountability, and litigation strategy all converge at roughly the same moment. Whether you think this trend represents a genuinely necessary push toward higher training standards or an overreaching legal theory that will simply make quality instruction harder to access, the underlying pattern is real, documented, and actively reshaping how instructors across the country are choosing to operate. It's worth sitting with the genuine tension at the heart of this trend, because neither side of the argument is simply wrong. Firearms training genuinely does carry higher stakes than most other skills-based certification, and a legal system that holds absolutely no one accountable for genuinely inadequate instruction feels wrong to a lot of people, especially families who've lost someone to a preventable tragedy. At the same time, an instructor genuinely cannot predict, and shouldn't be expected to predict, everything a student might do months or years after a few hours of classroom and range time, and a legal environment that punishes instructors for outcomes entirely outside their control risks driving good, careful instructors out of the field entirely, leaving only those willing to accept the risk, which isn't obviously a safety improvement either. This is exactly the kind of unresolved tension that tends to keep expanding through the courts for years before any kind of settled, predictable legal standard emerges. Whether that comes from state legislatures stepping in to clarify instructor liability limits, insurance industry standards evolving to fill the gap, or courts themselves gradually settling on a more consistent approach across different jurisdictions. If there's one thing worth taking from this breakdown, it's that legal trends like this one rarely announce themselves with a single dramatic ruling. They build slowly, case by case, through an accumulating pattern that eventually reshapes an entire industry's practices before most people outside that industry ever notice it happening. Whether you're an instructor thinking about how to document your own training program more carefully, or a student trying to understand what actually happens if your training was inadequate and it mattered later, understanding this pattern now puts you ahead of a trend that's only going to become more visible over the next several years. If this helped you understand a trend that's already reshaping firearms training right now, share it with an instructor or a student who's never thought about this side of the equation. Subscribe so you catch the next legal development in this space the moment it happens, and I will see you in the next one.